Well, now I will allow mention to be made, if any.
Please, Lordship. Lordship, I beg to make a mention on item number 8.
Number?
8, Lordship.
May I please, Your Lordship, that is a review petition and continuously they are taking time. There should be some continuously, my lord. Review petition cannot go like that only.
Lordship,
This has gone on too far.
Mr. Paul is out of station, Your Lordship.
Doesn't matter. He has his colleagues with him. You are there. You are competent enough.
Lordship,
By
let
this
this
time, you
matter
should
come
have
on Monday, Your
thorough
Lordship.
with the brief. Yes, Mr. Jarika.
Yes.
What do we do?
And it maybe makes as a fixed item, my lord.
Fix. Every day is a fixed item.
Yes.
The date that is posted is
Yes,
fixed.
yes, my lord. I am ready, my
What
lord.
else
But
do we have after that?
so what to do, my lord? As next Monday, my lord, it may be taken.
Time and again, the petitioner has sought for accommodation in this matter. Though the respondent, private respondent, is gracious enough to concede to such requests, however, considering the subject matter, it is urged upon this court that the matter may be definitely heard on the next date. The prayer made for accommodation is allowed. However, it is made clear that no further adjournment will be given. No further adjournment will be allowed. As prayed for, this is 1 week or 2 weeks. Be definite, because
On Monday,
we
Your
take it
Lordship.
up.
And then next week, Lordship, subject to your Lordship's
This is
convenience.
matter to 1 week.
Most
1 week.
of it, most of it.
May it please your Lordship. Lordship, I like to make a mention of item number 2. Lordship, this matter is already heard. Hearing is concluded, Lordship. We only have to file a written argument. Lordship, the arguing counsel is not keeping well, so I'm praying if this matter may be listed after 2 weeks.
You're for?
I'm for the petitioner, Lordship.
And for the respondent number 2, 3 and 4.
Have you filed your written argument?
We are yet to file.
I'm under.
On prayer made by the petitioner, some more time is allowed for the written argument to be filed. It appears that the respondents have also not yet filed their written argument. Accordingly, all the parties are called upon to file their written argument within the next date fix. This is matter after 2 weeks.
Highly obliged, Lordship.
I will please on. I beg to mention item number 5. 7. I'm praying for 2 weeks time, Your Lordship, as a senior is still on leave.
No objection, no.
Prayer for accommodation is sought for in this matter on the ground that the Leonard Senior Conducting Counsel is not keeping well and could not appear for this court today. Accordingly, matter is adjourned. List is after 2 weeks.
I'm praying for a similar prayer in item number 7. On.
Who's for the petitioner? Respondent?
Your Lordship.
You are there?
Yes.
Same order. Same order.
Lordship, I beg to mention item number 6. This is a joint prayer, Lordship. Lordship, may kindly take up this matter after 2 weeks.
You are for petitioner?
Yes, Lordship.
Yes.
No objection.
On pre-made by the petitioner, not objected to by respondent. This is matter up to 3 weeks.
Highly obliged.
On supplementary cause list, item number 1.
Yes, tell me the facts of the case.
My lord, this matter pertains to a motor vehicle accident, my lord, which took place near Anjali Petrol Pump on the 23rd of July 2002, my lord. Now, pursuant to the accident, my lord, the father of one of the victim, my lord, had lodged an FIR at Sada Police Station on the 24th of July 2002, my lord. And subsequent to the FIR, my lord, the accused person was booked under section 279, 338 and 427, my lord. Now, prior to the completion of the investigation, my lord, both parties have come to an understanding, my lord, and had decided to settle the matter to compound the proceedings, my lord. Now, my lord, because 279 is non-compoundable, my lord, hence I am before your lordship.
What does 279 says?
Negligent and rash driving, my lord. If I may take your lordship to the compromise deed, my lord, at annexure.
Where is the FIR?
The FIR is at page 16, my lord.
Page
Page 16, annexure 1, my lord.
16.
Yes, my lord. The type copy is at page 17, my lord.
Where's the compromise?
The compromise, my lordship, is at annexure 5, page 37, my lord.
Page?
Page 37. The terms are at page 38, my lord.
What does it say?
Clause 2, my lord, of the terms, my lord, is that now the first party, the accused person, hereby undertakes that all expenditure incurred by the second party, which amounts to rupees 3,20,000, which includes hardship caused by the second party and entire medical treatment of the parties represented by the second party, shall be borne entirely by the first party. Now, clause number 3, my lord, it talks about the installment, how the 3,20,000 is to be paid, my lord. So, clause 5, my lord, is that the second party is willing to compound the said case, and if ever the matter is charge sheeted in the competent court of law, the first party will compound the same and will not proceed with the case in the competent court of law, my lord. Now, my lord, in pursuance of this agreement, my lord, the accused person had advanced the 3,20,000, my lord, which your lordship may find the money receipt at page 50, my lord, annexure 7, my lord. Page 50 is the money receipt, my lord.
So you are the respondent too.
Yes, my lord.
What do you have to say about this?
We have no objection, my lord.
Heard, Mr. Counsel for the petitioner. Mr. S.A. Sheikh, Leonard J. has a
Your lordship, I'd like to place one judgment, your lordship, which your lordship had passed in similar situation, your lordship.
or Mr. S.A. Sheikh, Leonard J. appearing for the state respondent, and Mr. Leonard Counsel appearing for the respondent too. The Leonard Counsel for the petitioner has submitted that on 23/7/2022 at about at around 11:40 p.m. or so, while his cousin, who was riding a scooty bearing registration number ML05L8036 along with alien rider, was proceeding towards Laban from Maulai, and on reaching the junction of where the petrol pump is situated near the Anjali cinema hall, the petitioner, who was also riding a scooty bearing registration number 5ML05W8249 in a rash and negligent manner, collided with the said scooty ridden by his cousin, as a result of which his cousin, as well as the pillion rider,
Your Lordship, it's the cousin of the
respondent to
cousin of the respondent number 2, Your Lordship.
cousin of the respondent. He is the informant.
Yes, Your Lordship.
The last line. Written by his cousin, as a result of which his cousin, as well as the pillion rider, sustained injuries and were shifted to Nazareth Hospital for medical treatment. Next, thereafter, the respondent number 2 filed a lodge an FIR before the Sadar Police Station traffic branch, and a criminal case was registered, being, what is the case?
GR case number 72S of 2000.
Sadar PS case number 72
72S of 2000.
72S. Is that the Sadar police case?
It was charge sheeted, Your Lordship.
Charge sheeted.
Yes, Your Lordship.
Anyway, first give the Sadar PS case number.
Yes, case no 172 bracket 7 of 2022
2022. Under section
under section 279, 338 and 427 of the IPC.
on investigation being completed in the said case, a charge sheet was filed and a regular case was duly registered, being GR case number
72S of 2022.
pending before the court of the Leonard. Who is the court of whom? CJM or
Judicial Magistrate First Class.
Judicial Magistrate First Class Shillong? The case is at the stage of
Evidence, Your Lord.
evidence. How many witnesses have been examined?
It was fixed for evidence of PW1.
The case is evidence is yet to commence in the said case. Next, at this point of time, the petitioner has approached this court with this instant application under section 482 with a prayer to quash the FIR dated 24/7/2022 and the consequential JR case number 72 as 2022. The submission of the Learned Counsel is that the parties concerned have come to a compromise and understanding in as much as and to this effect a deed of compromise was executed between them. Where is that deed of compromise?
Page 37, Your Lordship.
Copy of the said compromise agreement dated 24/8/2022 being annexed as Annexure 5. In terms of the said agreement, the first party, that is the petitioner herein, has agreed to compensate the injured for all the expenses incurred by them in the course of medical treatment, which amounts to rupees 3,20,000. The respondent number 2 has also acknowledged and confirmed the said compromise agreement, and has also indicated that the sum of money which was assured by the petitioner / first party has been duly paid, a receipt of which is also annexed in this petition, being Annexure 7 at page 50. It is the submission of the Learned Counsel for the petitioner that since the parties have now settled the matter amicably, nothing remains as far as the dispute is concerned, and since a criminal proceeding is undergoing, particularly involving section 279 IPC, which is non-compoundable, therefore the petitioner has now approached this court with this instant petition and prayer as aforesaid. The respondent 2, submitting through his counsel, Mr.
J.K. Paryat,
has no objection to the prayer made by the petitioner and has concurred with the submission so made. In fact, the respondent 2, confirming the execution of the said compromise agreement and the receipt of all the sum of money which was agreed upon to by the parties, he would also submit that it would be just and proper and also a futile exercise if the proceeding before the trial court is to continue. Submission to respond of petitioner in support of his submission, the Learned Counsel has referred to a case disposed of by this court being reported in 2021 SEC Online Meg 236, which case is which facts and circumstances of such case is similarly placed with the case in hand, and in which case this court, having considered all aspects of the matter, has allowed the prayer of the parties therein. Prayer of parties therein. Mr. Sheikh, anything? Mr. Sheikh, I can't hear you. You have to teach me how to lip read.
Lordship.
Now I can hear you. Tell me.
Yes, Lordship. Here only the thing is that the compromise was not bona fide, Lordship, because the compromise was arrived by influencing the informant, Lordship. Otherwise, well, Lordship.
How can it be when the informant himself is before this court?
That's why, Lordship.
So, is there any inducement? It should have come from him. Mr. Sheikh has submitted that Mr. Sheikh Naraji has submitted that the role of the state in this matter is very limited, and since both parties have decided to compromise, there's nothing much to say in the matter. This court, on consideration of the submission made, without repeating the facts as has been stated, and on perusal of the petition as well as the compromise agreement, would opine that the case not being a very serious one, and the matter having been settled amicably between the parties, it would indeed be a futile exercise for the trial court to continue with the proceedings, and the matter would have been settled at the level of the trial court, but for section 279, which is non-compoundable. There are a catena of cases which particularly passed by the Honorable Supreme Court, which has given power to this court, even under section 482 CRPC, to compound a non-compoundable section of law under peculiar facts and circumstances of a particular case. In the case of ako tu ka case tu kayo tu ka 2021 ni ay ni kerteng mo gari Sinrob lang Dunai Rani versus State of Meghalaya. I biang tu hadir. In the case of Gari Sinrob lang Dunai Rani, this court has referred to this court, while deciding the matter, has referred to the case of Narendra Singh versus State of Punjab. Where's the citation?
The citation is page 7, Lordship. Narendra Singh versus State of Punjab.
2000, is it 2014?
2014, 6 years, Lordship.
2014-6 SEC 466, which is also relied upon by the petitioner at para 29.2 of the same, point 2, point 3, point 4 seped mo to. Puli biang tu paragraph ntar mo. The authority of the said Narendra Singh case would be equally applicable to the facts and circumstances of this instant case. Accordingly, this court is inclined to allow the prayer made. The resultantly the prayer the FIR dated 24/7/2022 and the subsequent GR case number 72 S of 2022 is hereby quashed. The petitioner is relieved of any liability in the said case. This petition is accordingly disposed of, no cause.
Really costless item number 1.
May it please, Your Lordship. Lordship, although this matter is for hearing, this is, my lord, in connection with the recruitment to the post of Garo lecturer, my lord. Lordship, on the last occasion I had, my lord, prayed that I may be allowed to file, I prayed for some time to obtain some RTI information, my lord, as to how the interview board is supposed to be constituted, my lord. So we have received the RTI replies since, my lord. I am praying for 2 weeks time to file it on by way of affidavit, my lord.
You have received?
Lordship, yes.
Why would it take you 2 weeks then to file?
1 week, my lord. One week. Very well.
And how is it relevant to the case? It's
No,
a
my lord, because
2017 matter.
No, our basic challenge is, my lord, that the expert member who was part of the interview board did not possess the requisite qualification to be part of the interview board. Of course, that is disputed by them. So we have tried to get from RTI, my lord, that what are the requisites, if any, for the constitution and who is supposed to be empaneled as the expert. Now, these are under MPSC recruitment. So we have received the reply, my lord. I can just bring it on record. It may be heard and disposed of on the next day, lordship.
Mr. as Deputy Counsel for the petitioner has submitted that the petitioner has made some RTI query and the response has been received from the concerned authority, department. However, it is prayed that the same may be allowed to be placed before this court by way of an affidavit. On prayer the same is allowed. Let the said affidavit be filed within the next date fix with an advance copy to the respondents. This is matter for 2 weeks.
Item number 4.
May I be pleased, Your Lordship?
Yes.
Your Lordship, we are newly appointed on behalf of respondent number 4. We have filed a Vakalatnama, Your Lordship. So I'm praying for some time, Your Lordship, 3 weeks time.
Yeah, you have already filed your affidavit, counter affidavit, isn't it?
Yes, Your Lordship.
So no fresh counter affidavit is required.
I don't think so, Your Lordship. It's listed for hearing, Your Lordship.
Heard Mr. Learned Counsel for the respondent. Learned Counsel who has submitted that he has just entered appearance on behalf of the respondent 4 and would require some time to peruse the brief, for which some time is sought for. As prayed for, this is matter to 2 weeks.
Can it be 3 weeks, Your Lordship?
3 weeks.
Much obliged.
Item number 9.
Lordship, I am appearing on behalf of respondent number 4. On the last occasion, my learned junior, he was appearing. But today I will be appearing on behalf of the respondent number 4 in this particular matter, who happens to be the defective complainant. We filed a Vakalatnama, which is also in the record of the court. That has happened, I think, before the last occasion. That is on the last occasion was 5/7/2023 sometime. So we have filed a Vakalatnama for respondent number 4.
Yes.
Lordship, am I audible?
You are audible but not visible.
I don't know, Lordship, but why this is not visible? Like there's some issue here. I'm trying to connect the video, but
Okay.
is it fine, Lordship? I tender my apology for the same, that I cannot.
It doesn't matter as long as you are
But there is some technical issue.
As long as you are heard.
I believe there's some tech. Yeah.
So you
So,
can go
yes,
ahead.
Lordship.
You are.
Yes, Lordship.
Just identify yourself.
Yes, Lordship. So I'm appearing on behalf of respondent number 4, my learned junior.
Identify yourself.
Yes. So you can identify me, right, sir?
No, I said, are you Basabraj?
Yes, sir. Yes, sir.
Okay.
Yes, sir. Yes, Lordship.
Chakraborty.
Yes, Lord. Yes, Lordship. Absolutely.
Tell me,
So, Lordship, now the situation I'll tell you, the de facto complainant, who happens to be the respondent number 4, so he is a senior citizen. He has different kind of ailments, and for that, he has gone to his son who stays in USA. So he is not available in the country till the month of around October end. And as he is the de facto complainant on whose pretext this FIR has been filed and which they have come up for quashing, so I think I need to seek more instruction from the respondent number 4. So I would request your Lordship on that pretext that if your Lordship can fix it sometime after the month of October.
How can it be? It was a long time.
Your Lordship, I am appearing in this matter on behalf of petitioner, Your Lordship. Is this item number 9, Your Lordship, I guess?
Yes, just a moment. Let Mr. Chakraborty finish his submission.
Yes, Lordship, I know I'm seeking for a long time, but the situation here is like that, as because the de facto complainant himself is not available. So I think once he is back, let me seek particular instructions how to go ahead and what are in the meantime the state, if they want, they can make their submissions. Lordship can fix it for any other day where the state or the petitioner would like to make submissions. But in order to conclude the hearing
will be taken in the presence of all the parties.
Yes, that's what I'm saying, Lordship. Absolutely. Much obliged. Much obliged. Much obliged. So, Lordship, my only prayer is that if it can be posted sometime after October.
Your submission is noted. Yes, Miss. Yes, Miss.
Your Lordship, I just wish to make just one submission, Your Lordship.
Tell me.
My learned friend Ritwaj Ramana, I guess he has also joined. He is also one of the co-counsel for the petitioner.
I'm also facing the same technical problem. The video is not being visible. My face is not being visible. If I may be permitted, if I may be given a minute, I could reconnect again.
No, you are Mr. Raman.
Yes, my lord.
Okay, please go ahead. I can hear you. So
my lord, on several occasions, lastly, we had waited for respondent number 4. We had served them the notice way back on 20th of March itself. They have received on 20th of March itself. We waited for 2 further dates. Then the council on behalf of them had come and asked for the petition. We had given them the petition. On the last occasion as well, they had said that on the last occasion the informant will be appearing, but the informant did not appear. So with the consent of the respondent number 4 itself, the date for today for final hearing was fixed.
Lordship, here I would like to interfere if your Lordship permits.
Just a moment. I've heard you, Mr. Chakraborty. Your submission is noted.
Yes, sure.
Let Mr. Raman complete his submission.
Sure, your Lordship.
Please continue, Mr. Raman.
Yes, my lord. The informant, in the role of the informant in the present case, has nothing to do with the allegation against the petitioner. In the first information report itself, the informant had not lodged the FIR against anyone. The FIR was lodged against unknown person. Then it was during the course of investigation that the police had alleged against the petitioner and got her role in the present case. So there is no such particular role of the informant in the present case.
Whatever the case may be,
this would be my
Mr. Raman. Whatever the case may be, you have arrayed him as respondent in this case.
Yes, ma'am.
So he has to be heard. Opportunity has been given.
My lord, definitely.
He has submission has been made. Accommodation has been sought for. So what this court can do is, we will adjourn this matter, and at this point of time, if you are praying for any interim prayer, that may be allowed. If not,
my lord, we have annexed a petition for the interim prayer that for time being the proceeding may be stayed.
What is the stage of the case?
The charge sheet has been submitted and nothing further has happened in the present case.
If charge sheet has been submitted, you will be summoned in due course.
Yes,
So as and when,
yes, my lord, but
as and when you are summoned, you can make a prayer before the trial court if you wish to be represented, or if you want to appear personally. That is up to you. But apart from that, I don't think proceeding will continue. Huh?
Meanwhile, no coercive action may be taken against the petitioner if at all.
Where is this issue of coercive? Are you on bail?
Yes, ma'am. The bail has been granted.
Then what else?
Yes, ma'am.
What is there? What coercive action?
Charge sheet is also filed. Nothing adverse will happen, Lordship. I don't think.
My lord, if at all, my humble request is if at all, if something.
We'll do one thing, Mr. Raman. I'll post this matter to 3 weeks. If anything happens within that 3 weeks, you can come before this court and make your submission. And Mr. Chakraborty, you can also,
yes, sir. My lord.
You can also, you see.
Yes, sir.
It doesn't matter. You see, nowadays, distance is not a problem. You can seek instruction, seek adequate instruction, and then either you appear, as I've stated earlier. If your client wishes to appear personally, the visual mode is always there.
I am there, Lordship.
Yes,
I am there on representing my.
So you get your instruction.
I am representing my. Yes, Lordship. I'll do that.
So,
in this 3 weeks' time, I'll seek adequate instruction from my client. But my submission to that effect be noted that my client is not available in the country till October.
That like I said, Mr. Chakraborty, that would not be tenable, not in this day and age.
No, Lordship. It's just a humble request of mine. If Lordship can just record the submission that the petitioner, the respondent number 4, he is not available till October. So his personal presence would be a little difficult. I don't think that will be required because I'll be appearing on behalf of him. I am representing him.
You are contradicting yourself.
Still. Still, I know, Lordship, what you're saying. To sort proper instructions, you understand, Lordship. I have to sit with the client, I have to get, and he is a senior citizen, so he's at his son's place in United States. So I just request that at least I may be heard after October. Let the other parties, let his application may be heard. Sorry, Lordship.
Fine. Initially, I'll grant you 3 weeks' time, but I don't think I'll give you any more latitude.
Absolutely, Lordship. I am much obliged. No problem.
Mr. B. Chakraborty, the counsel for the respondent number 4, has submitted that his client is not in station. In fact, he is out of the country, and therefore necessary instruction as far as this matter is concerned could not be obtained. In view of his absence from the country, the learned counsel has prayed that this matter may be posted to be heard sometime in the month of October. Learned counsel for the petitioner, Mr. R. Rahman, has countered the submission by stating that the facts and circumstances of the case would not merit the presence of the respondent 4 to be heard in the matter. However, there is no strong objection to the prayer for adjournment of this matter for today, except for the prolonged period of about 3 months or so. This court, on consideration of the submission made at this junction, would allow the prayer of the parties, particularly the respondent number 4, for adjournment of the matter today. However, at this stage, the adjournment will only be given for a period of 3 weeks. the Land Council for the respondent 4 is requested to seek necessary instruction and to be heard in this matter definitely by the next date fix. As paid for, this is matter of 3 weeks.
Item
Deeply
number
obliged.
Thank you.
Deeply obliged.
It's posted today for filing of written arguments from my side, my lord. I've filed. I've given a copy, my lord.
I've already filed, my lord. The earlier occasion.
You filed yours?
Yes.
This is that matter with the sanction signed by the
yeah.
registrar.
I think it's only on a question of law,
Absolutely, my lord.
whether who's the competent authority
Absolutely, my lord.
to issue the sanction.
Yes, my lord. The only argument is, my lord, if it is the executive council, then my argument is that the executive council should sit because they are a body of individuals. For them, in order to peruse the materials on record and to come to a conclusion, there has to be a meeting and there has to be a resolution on the basis of which they can act upon. Now, either it is the registrar, even if they say that the registrar can sign on behalf of the executive council, then there has to be a resolution on the basis of which the sanction is done.
That is natural. I think you must have covered that.
My lord, I have annexed certain decisions, my lord. Where the Supreme Court has said that there are two situations, my lord, where the absence of sanction, my lord, and where they are saying that there is some irregularity in the sanction. This case is not an absence of sanction. Sanction is there, my lord. Only question is whether the registrar was competent to sign on behalf of executive council or not. And second issue they are raising is there are no application of mind. My lord, my friend has annexed one judgment, my lord. That's supporting my case, my lord.
Well, that judgment basically, my lord, I have two lines of argument here.
My lord, may I just complete, my lord? But the first judgment my friend has annexed, my lord. This is PL Tatwal 2014 volume 11 SSC.
Yes.
My lord, lordship kindly turns to para 16, my lord.
Yes.
In such circumstances, we are of the view that the trial court should conduct a proper inquiry as to whether all the relevant materials were placed before the competent authority and whether the competent authority has referred to the same so as to form an opinion as to whether the same constituted an offence requiring sanction for prosecution. In that view of the matter, we set aside so and so, so and so. Now, my lord, in the same judgment, para 13, my lord, the Honorable Supreme Court has quoted its earlier decision, my lord.
Yes.
It says, in a recent decision in State of Maharashtra versus Mahesh G. Jain, the court has referred to the various decisions on this aspect from para 8 onward. It has been held so and so. In Muhammad Iqbal Ahmad versus State of AP, this court lucidly registered the view that it is incumbent on the prosecution to prove that a valid sanction has been granted by the sanctioning authority after being satisfied that a case for sanction has been made out constituting an offence, and the same should be done in two ways. Either by producing the original sanction, which itself contains the facts constituting the offence and the grounds of satisfaction, and two, by adducing evidence eliunde to show the facts placed before the sanctioning authority and the satisfaction arrived at it by it. It is well settled that any case instituted without a proper sanction must fail, because this being a manifest defect in the prosecution, the entire proceedings are rendered void ab initio. My lord, I am stressing on the second point, my lord. By adducing evidence eliunde to show the facts placed before the sanctioning authority. So, my lord, my case is that all these issues are to be decided by the trial court in the course of trial, my lord. My lord, with my written submission, I have given.
Excuse me.
But earlier also I placed two decisions, my lord. One was 2012 volume 1 SSC.
Page
2012 volume 1 532, my lord.
Yes.
My lord, para 9 of this judgment, my lord.
Yes, you have referred to this.
I have referred to earlier, my lord. Where Supreme Court has said that absence is one thing, my lord, and a situation is altogether different. When sanction is there, then they are challenging that this is without application of mind, or this is not by the competent person, my lord. In that case, that is a subject matter of trial, my lord. There they can take this defense and the trial court will decide in the course of trial, my lord. The same view has also been taken in the other decision I placed, my lord, 2020 volume 17. Para 11, my lord. May I just read, my lord? It's one para, please. Further, the issue relating to validity of the sanction for prosecution could have been considered only during trial, since essentially the conclusion reached by the High Court is with regard to the defective sanction, since according to the High Court, the procedure of providing opportunity for explanation was not followed, which will result in the sanction being defective. In this regard, the decision in Dinesh Kumar vs. Airport Authority of India relied upon by the learned Additional Solicitor General would be relevant, since it is held therein that there is a distinction between the absence of sanction and the alleged invalidity on account of non-application of mind. The absence of sanction no doubt can be agitated at the threshold, but the invalidity of the sanction is to be raised during the trial. In the instant facts, admittedly there is a sanction, though the accused seek to pick holes in the manner the sanction has been granted and to claim that the same is defective, which is a matter to be considered in the trial. So, my lord, in my humble submission, that opportunity they have, my lord. The trial is yet to commence, my lord. They can be at liberty to, my lord, to agitate in the course of trial, my lord.
Well, if I may give a small reply. Well, the reason why I've come here under 482 is because, my lord, the trial court, while passing the order on my application for discharge, my lord, if lordship will come to page 97 of my criminal petition. Page 97. So, paragraph 51 of the impin order.
Yes.
Well, may I read it out? As per Rule 13.2 of the Executive, the Executive Council is the appointing authority of the accused. A1. It is abundantly clear that the contents of the prosecution sanction that the prosecution has been accorded by the Executive Council, which is empowered to appoint professors, readers, lecturers, and other academic staff under Rule 13.2. Clause 2, as per Rule 4, Clause 5 of the statutes, the Registrar is the ex officio Secretary of the Executive Council, Academic Council, and the Board of School. And under Clause 4.6d of the statutes, he is to conduct the official correspondence of the court. The Executive Council and the Academic Council, the prosecution sanction has been issued by the Registrar on behalf of the Executive Committee. Now, look, next page, it is abundantly clear that by issuing the prosecution sanction, the Registrar has not initiated any disciplinary action against Dr. Dinesh Bhatia as contemplated under Rule 4, Clause 4. Clause A of the NEHU, subclause A of the NEHU statutes. Now, paragraph 53, my lord, the learned court says, in view thereof, the court is of the considered view that there is no illegality in the prosecution sanction as it has been issued by the authority competent to remove him. So, my lord, by coming to this finding, my lord, that bracket of me raising this issue is totally gone. I had raised this issue at the very threshold that the prosecution sanction is not proper. So, what my learned senior has pointed out is also, I mean, I do agree to his submission to a certain extent that the trial court can look into the matter whether the prosecution sanction is faulty or not. Well, my argument here is that, my lord, the fact that the prosecution sanction was signed by the registrar without there being a meeting and without there being a resolution, that is no sanction in the eyes of law. So, my lord, by coming to a finding at paragraph 53, the trial court has taken away that opportunity from me to even agitate that.
If the issue has not been discussed or dealt at length with by the trial court, it can still do it.
So, my lord, until unless this paragraph is there, my lord, my problem will be, my lord, I can file an application for the prosecution to bring evidence and show that the sanction is proper. But as long as this order is there, my lord, that opportunity will not be there with me.
Well, this
is our duty to prove the sanction, my lord.
Yes.
Because this is the first step, the first threshold.
That's what I said. The evidence still has to be led. So to that aspect, to that extent, this court can, modify the.
Well, that can also be done, my lord. Because then what happens, my lord, I can file an application under Section 19, the relevant provisions.
But in my humble submission, this observation is only for the purpose of 227 application.
Exactly.
227.
Only
so,
for
my lord, in my humble submission, this will not be binding on the trial court.
Prove whether there is sanction or not, whether it was issued by the competent authority or not.
It's a matter of trial. And
But so the court may have come, we don't know, may have come to the conclusion that that aspect of the matter, there is no illegality.
my lord.
But the sanction per se being illegal, that is a different matter altogether.
Well, my submission is, my lord, if there is no sanction, then my lord, even the trial should not commence. So, my lord, and I have to raise it at the very beginning, my lord, because otherwise, if I raise it at the fag end, the prosecution is going to make the argument that I have not raised it at the proper time.
So as Dr. Muzika said, see what this court can do, this court can modify this order.
That can also be done.
Allow you to appear before the
My lord, in
and
my
agitate
in my humble submission, this much observation that this finding is only for the purpose of that 227 application.
in whatever way, the meaning has to be conveyed.
My lord, that there is still at liberty, my lord.
There is still liberty. See,
that I cannot
can
say
still
no, my lord, yes.
agitate. You see, before the competent authority. To that extent, you have to give him, because, as you rightly said, evidence in this regard has not been led.
Not been led, my lord.
Parties have not been heard.
My lord.
So the trial court per se, could not have come to
this finding,
as it is.
If why trial court did, my lord, they filed a discharge application, my lord, on the ground of.
Not only on that ground, there were other grounds raised also, my lord. Here I raised this.
So the trial court has to give a finding on discharge application also, my lord.
So the trial court could have said that, my lord, I could have this particular aspect could be dealt with at the point of trial.
Yes.
So the trial court has put a seal on the prosecution sanction, which I say is faulty, by saying that, my lord, this paragraph 53, in view thereof, this court is of the considered view that there is no illegality in the prosecution
we
sanction.
will accept the fact that the trial court has disallowed your application for discharge,
my lord,
and the trial will commence.
My lord.
Now, when the trial commences, then you will be allowed to agitate on the issue of sanction.
Well, otherwise, my lord, lordship will perish by written argument. If lordship finds substance, then maybe my lord, lordship may exercise powers under 482, because, my lord, my argument is twofold. I also say that there is no sanction because there has been no resolution, there has been no meeting, it has just been categorically signed.
Right. That will be.
If not, then, my lord, this particular opportunity should be given to me. Otherwise, my lord, my chance of agitating this will not. Well, they will definitely raise this objection in the trial court. Somebody else will appear, will say that in passing the order declining my prayer for discharge, this has already been dealt with. The court has come to a finding that there is nothing wrong.
This court will make note of that. So I've heard the parties. I'll pass this order.
Much obliged.
Much.